Hi, this is Simon Lee, a lead lawyer from Pureum Law Office. I have been practicing Korean criminal law for foreigners since 2014 in Seoul. Today, I would like to share my knowledge and experience regarding Korean criminal procedures and give you some tips you might need when you are involved in a criminal situation. Yes, there are two exceptions of the principle of arrest by warrant. The first one is the arrest at the scene. If you get caught your criminal behavior in the scene by anybody, including the victim or pedestrians, they can capture you until the police arrives and you will be under arrest by the police without warrant. However, the police must inform you the Miranda rule right before or after the arrest. Second one is the emergency arrest. This can be executed by the police or prosecutors when they have justifiable reasons to think that you committed one of crimes may cause death penalty, life sentence, or jail time not less than 3 years. After the execution of arrest, the police have 48 hours to request the warrant to the judge with the prosecutor's permission. So the police will have the initial interrogation with you to see if there are enough grounds to maintain the confinement, then make a decision in 48 hours. You have a right to be silent and hire a defender, so you can tell them you won't speak anything until your lawyer arrives and start looking for the lawyers. If you don't think a lawyer is necessary for your case, you can just go ahead and participate in the interrogation without having the lawyer next to you. If you have a fixed address, regular job, some family members in Korea, or if you admit your charges and no evidence left to be destroyed, they may release you after the initial interrogation. But there's a very high chance they request the warrant to the court only because you are foreigners. So you have to do your best to show them how strong bond you have to Korean society by showing period of you have stayed, the position you have, the money you make, and the Korean friends you know. If they request the warrant with the prosecutor's permission, you will have a hearing called examination of the necessity of warrant in 24 hours from the request. You will see the judge and you will have an opportunity to make arguments regarding the necessity of the warrant for this case. If the suspect is arrested with the warrant, the police and prosecutor's office can only have the suspect to arrested in 10 days each, and the district court has to finish the case in 2 months. So it is very likely for arrested suspects to have a speedy trial. For the suspects not arrested, there is no time limit for the investigation or trial by law. So it will take longer than the case the suspect is arrested. Usually, it takes 1 or 2 months for the investigation and takes 2 or 3 months for the trial unless the suspect or prosecutor appeals to the court decision. You shall be present to listen to the sentencing on sentencing day after the hearing is closed. The judge will deliver the result while you are standing in front of the judge. If you cannot accept a court decision, you need to make an appeal in 7 days from the sentencing day. It is not 7 days from the date you receive the court decision at home, since they never deliver the court decision to your home, unlike the civil procedure. If you or the prosecutor don't appeal in 7 days, the court decision will be determined and it will become impossible to be reversed unless going through the retrial process. As a suspect, you must have a lot of excuses and defenses of the behavior in question. So you need to hire a lawyer who is willing to listen to your arguments very carefully and clearly and try to understand the situation from your position. So speaking your own language is necessary. You need to stay away from the defender who guarantees the favorable result based on his or her experience, but rather to choose the lawyer who is very careful and remains the objective attitude while the lawyer-client meeting by bringing the weakness of your defense, asking many questions about the situation, and even suspecting the liability of your own statement. In Korea, asking for contingent fee in exchange for having favorable result, such as release order or not guilty verdict, has become illegal since July 2015. So if your lawyer asks you to sign in the agreement with the contingent condition, you may not want to hire the lawyer for moral reasons. There are many good English-speaking lawyers in Korea. I hope you to choose the best one for your case if you get involved in criminal case. But most importantly, please stay away from troubles. Don't forget your vulnerable status as a foreigner. And never get involved in any criminal situation in Korea. Thanks for watching. See you soon. 든든하고 명쾌한 법률 상담. 변호사님.com